But we got photos, we got audios.
Oh, it's okay.
I'll give an offer, but I don't. You should not just leave it out. That if that makes sense. You know, when you get a short turnaround, get to the deadline. And
Is he having?
I think, yeah, you can find it. Once.
Everybody wants something.
Except for here, like. Wait, it's just.
Yeah, like it goes through all the. Very certain, this also shouldn't have any. You wanna be like, I wanna say.
So I just put the note. I was wondering.
I just need to reflect the memory of, which is a long.
Yeah.
Yeah.
So.
I know, we're on the same page.
Okay, cool. All right. So we've been involving interviews. And then there's multiple paragraphs. Yeah, there's multiple paragraphs in there.
Hey.
You guys still in it?
Yeah, still day 3.
It's at 9.
Wow. We pushed down to 7, but I think we might just do 8. I think we're gonna finish up my direct of the investigating detective. Then I think we got like 2 more. I think
Okay, so maybe you can submit it today.
that unless something ridiculous happens, then we will be wrapping up today. And then Melissa will start her bit.
It's good. Okay, then get some reading. Hopefully finish by then.
Honestly, I'm hoping we do closing tomorrow morning and then shoot the jury back and just see what happens. That would be nice. You okay, man? You sound fine.
Yeah, doing good, This shirt will tie in my
Oh.
neck, so we'll get against the.
I usually always just undo the top button and just like really cinch down my tie. Yeah,
I think I'm afraid like it'll come on kind of like sideways a little bit or something.
Yeah, and I was like, look, those guys. You've always dressed in textually, so.
Oh, thanks. Yeah, that's right.
No.
Little things here and there. And obviously, the dry cleaning bill is there, pants, but luckily my wife has the shirts, so that's all right.
One thing I hate about trial is that I go through all my suits real quick, yeah. Especially during the summer or during like the warm months. It's like, yeah, I got like one suit left after this.
Yeah, like next week, oh shit, I'm gonna have to like piece
Yeah.
stuff together.
I'm gonna have to come in with like a polo shirt and something be like judgmental, but I'm out. Not a suit then.
So those public serving here, Judge. We have you better sit things.
Yes, I was talking to Megan. She said she was gonna handle that because I'm like up to middle of.
Okay, sounds good. I'll speak here.
Okay.
I'll let you focus on this month, bro.
Okay, thank you, man. Thank you.
Yeah, it's a pleasure.
Absolutely. But I think I read your previous.
Yeah. I know, you guys go, yeah.
This is very soft.
All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Gustavo Jimenez, custody. Jesus Alberto Villasana Avina. Turk Lemes, custody. Joe Rodriguez, custody. James Edward Sanchez. James Edward Sanchez. Jeremy Bass. Adrian Harper, custody. Caitlin Medell, custody. Matthew Hill. Adam Cruz, custody. Edward Vera Jr. David Lopez Gonzalez. Joseph Sebastian Gonzalez. Luis Salinas, custody. Cesar Robles. Anyone who's not here by 9:30 goes into custody. Demontre Gaines.
Council's present, Your Honor.
Omar Contreras.
Present, Your Honor.
Allison Gould. Thank you. Norma Colmack. David Lopez Gonzalez. Thank you. Jacob Montez, custody. Megan Popnick. Megan Taylor Popnick. Marcos Espinoza, custody. Daniela Bustos. Edgar Pascal Santa Cruz Trejo. DeTrader Collins.
Who's present? I'll.
All right, Jesus Hinojosa Perez. Anthony Gallardo. Thank you. Tayshawn Smith. Tayshawn Kendall, Kendall Tayshawn Smith. Alexander Rivera, custody. Jeffrey Davila, Bond, thank you. Brianna Montez. Caitlin Medell, custody. Pablo Hall. Pablo Hall. Raimundo Rubalcaba, custody. Maurice Mercado, if you're here, your case was dismissed.
Council's here. I saw one dismissal yesterday and then I didn't see the second one.
All right, if you'll confer with the state. Daniel A. Gold. All right. Jamie Vestel is by Zoom. Jonathan Vargas, custody. Madison Delozer. Jose Terry Beatis. Arnold Pena. That's at 10. Aristed Brown. Daniel Friend. Dwayne Daniels. Henry Peterson. Alejandra Alamanza, custody. Adrian Harper, custody. Anyone who came in later, your name was not called? Yes.
Sanchez,
I'm sorry, what?
James Sanchez.
All right, just have a seat. We'll get with you. Yes. I'm sorry, what?
Mark begins.
All right, thank you. Anyone else? Sir, you need to find a seat. All right, attorneys, these are the rules of the court. You're not ready to approach me unless you've conferred with the state and conferred with your client. If your client is in custody, yes, your client needs to be brought out. If you are seeking probation for your client or your client is on probation, you need to confer with probation. When we're on the record, do not speak behind the court reporter. If you have someone who's in the box, just raise your hand. We'll move you to the other end. When you are ready to approach, please confer with the clerk and let them know the reason you're approaching, because we're going paperless. That way I will know the reason you're approaching. All right, everyone, please confer on this Friday Eve.
Morning, good.
Good morning. How you doing?
Fine, how are you?
I'm doing okay. Just give me a moment.
Yeah, he did after hiding in the regular aisle.
No, he said James Sanchez. Yeah, he's on the docket. Sure, just have a seat. Thank you.
Thank you.
All right, who's ready?
Yeah, that's not what I'm concerned.
Oh, it's a female.
Oh, I'm sorry.
Your Honor, I don't know if you remember, this is.
I
the-
do.
Okay, okay,
Yes.
perfect. So I filed the motion and then pretrial issued a violation report for my client stating that she picked up 3 new cases, even though it was the other individual that technically picked up those
Have you
cases.
conferred with the
Yes,
state?
yeah, they're aware.
Miss Cindy?
Yeah, I talked to Megan and Brandon, they're obviously both unopposed to the motion
Okay.
and they're aware of the violation report.
Yeah.
Okay.
Because I don't see. So she can sit here since Paris is. Okay. Yeah. Yeah.
So none of the first one. None of the first one.
Yes. Welcome. Yes, oh no, I remember you. Okay, all right, thank you. Hi. Good morning. Good morning.
Good
Are you
morning.
gonna be for the trial as well?
Tell me if you have them. I'm having a hard time hearing.
All right, well, welcome, Ashley.
Yeah.
All right, so one, I understand what you want with your motion.
It's very, very low. I can't hear anything. It's coming from over there.
Is there a volume button on here?
It's all the way up. It's gotta be their side. Well, no, I mean, it's, why is it coming back from over here and not over here?
Let's try this.
Okay, but they just put it on mute so we can hear it now. I don't think it's this side. I think it's their side.
Try clicking. Is there a
Yeah. So, oh wait. Oh, no. Okay, that's all we can do from this side, right?
hey, should be good.
Thank you, sir.
Yes, ma'am.
No, it's gonna be, it might be this side. Can you turn that white noise off?
You did turn it off.
Sorry. Explaining everything, you know. Yeah, just because those cases have computer. Which doesn't have speakers like it should.
Hi, excuse me, just give us a moment.
Okay.
And then with regards to this, oh, they've already sent it to me.
The violation report, Judge.
Yeah, with regard to the violation, oh, they didn't send the back one. Norma,
Yes, ma'am.
can you let them know they didn't send me? Tell them that. All right, so with the violation reports, I'll put on here, if everybody's agreed that she's not the person who committed the violation.
Yes, I don't have any reason to believe she's.
All right, and then what we'll do, we'll recall this for, let's see. All right, we can recall it on May 28th.
Yes, Judge.
All right, it's National Hamburger Day, but we can still do it. All right, so we'll recall it for May 28th.
Okay, yes, Judge.
All right, Norma, that's being recalled for May 28th,
Okay,
and you can appear by Zoom.
all right, thank you.
Thank you. And then I will take care of this.
Yes, Judge.
Thank you. No, it's to work out this identity issue. All right, thank you. All righty, thank you. Do you need to speak with her in the breakout room or no?
No, Judge, I always, I just wanted to make sure she knew she could log off.
All right, she can log off.
Oh, okay, thank you.
Yes.
It is,
All right, who's next?
Yes, Judge. That's why I was sort of lingering. Yes, Detrader Collins. He did not appear, Judge. His bondsman filed an affidavit of surety yesterday, and I believe that was already signed off. I talked to the bailiffs about it. I have never had contact with him. I have
Okay.
tried. I've contacted the bondsmen, I've contacted pretrial, I've called, texted, every which way you can imagine, and I've never had contact with him. So he does already have an active warrant, but I just wanted to let the court know what was going on
All
and
right,
why he
thank
didn't
you.
appear.
Thank you.
Yes, Judge.
my main thing is I always get.
All right, who's next?
Can I speak or?
Yes.
Okay, thank you.
Yes.
Yes. Yeah.
Megan Popnick.
I'm here for her. She let me know she's walking in, probably about 5 minutes before she's here.
Okay.
Thank you.
Thank you. Anyone else ready?
And then, Dimitri Gaines, I should be one of those.
Yeah, yes.
Dimitri Gaines. Gaines, come forward. Why were you late for court?
I catch Uber and it was a long wait time. I woke up late today.
All right, so here's the thing. Court is at 9. You need to make sure you're on time. You understand? That's yes or no?
Yes, ma'am.
Okay. All right, so offer is due today.
Yes, Judge, offer was extended. I did review the evidence we received, and I'm still fighting with the follow-up unit regarding some videos I think are in existence. I have asked for clarification on 6 videos, but we did receive all the photos, audios, and the dash camera that I requested. So I'll keep on that. So I'm asking for 2 additional weeks.
All right, Ms. Ferguson, put this at the end of May. You all will need to confer off docket. I'm going to set your plea deadline date for the end of May. Of course, if there's some issues with the videos, the court will extend that. All right, May 26th, make sure you're here on time, all right?
Yes, sir.
All right, thank you.
Thank you, Judge.
All right, who's next? Okay. And Norma, have you called Mac?
Let me call. Mr. King, don't leave without signing your reset. Y'all call him right now. What's the name? 160. 160. Well. Speed is life of hesitation. I used to sit there and practice stage on the TV, so I could watch the shows and fall.
Okay.
Great thing to say. You just say things. Just all business. It's like. We do have a very something here, I think, right? No, go ahead. Like. Second one. Yeah, I'm doing that. Associates for years, and she's Esquire. Oh, yeah, it's right now. I'm not. The judge, right.
Okay. Okay, just give me a moment.
So she was. I always remember that. Yeah, it sticks with me. Yeah. As I think she. Oh, did you sign in for? I've been here just for years. Doing dictation for years. And a medical transcription.
All right.
I never took classes, but we just, in my mind, I got a job at example. We worked out there for a while. Then I got a job at. What's this? Doing their. No. Well, it helps, especially like my first depot was about, honestly, it's all that very good to say it, so. I'm like, oh, thank goodness, I was being there. You say, and then, we would say, our words of the poems. So what we learned, and I'd be the teacher. Oh,
Calling the family.
Megan Popnick. All right, where are we on discovery?
Your Honor, we just requested EMS, CPS, and we should be getting those within the next couple of days. I already talked to the defense attorney. She also gave me a mediation package, so I'm gonna be reviewing that.
All right, and were you able to tender an offer?
Not yet, Your Honor, because we're still missing those.
All right, Ms. Ferguson, recall this for 30 days. At that time, you all need to be prepared to tender an offer.
Yes, Judge.
Thank you, Your Honor.
Sure,
Thank you.
you're welcome. Who's next? Okay. We are going to get something on the record for you. Discovery and offer due. All right, Mac? Hello. State on Allison Gould, do you have all discovery? Okay. Norma, set this for mid-June. Mm-hmm. And states you need to be prepared to tender an offer at that time.
Yes, Judge.
All right, thank you. Okay. All right, June 16th. Once you sign the reset form, you're excused.
Yeah. Was there anything else you're in?
If Norma. All right, thank you. I'm ready.
Okay, I apologize, I'm not ready.
Excuse me.
What are you doing in my bathroom? Stuff, and I'm making my setting. My grandson stayed outside and bring everything into the lodge, so that it's stolen. I ripped everything out and there was on myself. Because every time I face them. Yes, autograms. This is why. They didn't get a question.
Yeah.
All right, yes.
Yes, that's them, Adrian Parker, page 3.
Court is calling 2025 CR 01275. I'm sorry, correction. 2025 CR 01275, State versus Adrian Harper.
Oh,
Can I have parties announced?
Brandon Prada for the state.
Fernando Trevino for the accused.
And where is Mr. Harper?
He's here. He's in custody.
All right, so where are we on discovery?
No, we just trying to get a bond set, Judge.
All right, so I need to know where you all are in discovery also.
I believe all discovery's been tendered.
I'll be happy to download.
All right. And then is there
There's an agreed amount on the bond.
no, I need a motion. Do y'all have a motion?
No, we don't.
You have any objections to an oral motion?
None at all, Judge.
All right, there's a request for a bond. Defense, it's your motion.
Yes, I'd like to request a bond for Mr. Harper. Do you have a job?
No, I mean, you all are whispering, the court reporters can't hear. And are you calling him as a witness?
I was asking a question.
Well, I mean, then he needs to be sworn in.
Okay. Cool.
All right, so you're calling Mr. Harper?
Mhm.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adrian Jelani Harper.
All right, you may proceed.
Mr. Harper, if the judge grants you a bond, amount of 7,000, would that be something you'd be able to afford?
Yes, sir.
And the state has agreed to do so, Judge. Same amount.
All right, so everybody's whispering, and we're gonna go off the record briefly. Counselor, you may proceed.
Well, Your Honor, he's had this case pending and original bond was at $3,500 and he failed to appear and a warrant was issued and he's in custody now. And you can afford a $7,000 bond, Judge.
All right, so this is what the court needs to hear according to the new law. Number one, is he a flight risk? Number two, he failed to appear. So did he fail to appear wantonly or, why wasn't he present? Nobody's telling me this. Everybody's just coming to me with an agreement. And according to the law, I'm not allowed to do that.
Judge, if we could step back for a moment.
Sure.
See for the here.
All right, who's next? Anthony Guardo. Hello. I'm gonna work on pronouncing your name correctly, I promise. All right, so you decided a discovery acknowledgement
That's correct, Your Honor.
and has an offer been tendered?
It has been tendered.
All right, sir, how old are you?
I am 47.
All right, Ms. Ferguson, I need a plea deadline date in 3 weeks. All right, once you sign the reset form, you'll be excused. Thank you. Anyone else ready?
Jonathan Barton, page 940.
I'm sorry.
He hasn't run out yet.
Please sign it and make it.
But it's Mandel is first.
Yes.
Down.
All right, Dwayne Daniels.
Morning, Your Honor.
Good morning. Court is calling 2022 CR 0695 State versus Dwayne Daniels. Can I have parties announced?
Monica Cheta for the state.
And Tim Molina for Mr. Daniels.
And are you Mr. Daniels? Review the motion to enter adjudication of guilt and revoke community supervision with your attorney. Did you understand it?
Yes, ma'am.
Are you the same Dwayne Daniels who's placed on deferred adjudication in 2022 CR 0695 for the offense of assault, impeding circulation on January 11, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, we're waiving condition number 1 and we're proceeding on violations number 34, 36, and 37. I'm gonna start with condition number 34. On or about the 21st day of February 2026 in Bexar County, Texas, the defendant Dwayne Daniels, the tenant there, failed to attend and successfully complete a parenting program with an approved agency in violation of condition number 34.
How do you plead to that? True or not true?
True.
I'm gonna proceed with violation number 36. On or about the 11th day of February 2026 in Bexar County, Texas, the defendant Dwayne Daniels, the tenant there, failed to attend and successfully complete a moral recognition therapy program with an approved agency in violation of condition number 36.
How do you plead to that? True or not true?
True, ma'am.
Proceeding on violation number 37, on or about the 11th day of February 2026, in Bexar County, Texas, the defendant Dwayne Daniels, the tenant there, failed to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program in violation of condition number 37.
How do you plead to that? Is that the only allegations you're?
Yes, Your
pursuing?
Honor, the state is recommending revocation.
Want to know? The other allegations, are you waiving those?
Yes, I'm waiving condition violation number 1.
Any objections to the waiver?
No, no, Your Honor.
Your Honor, does the court have other violations other than the ones that we read? Apart from the condition?
All right, and your name for the record?
Ashley Jones for the record,
Yeah.
sorry, Judge.
No.
Okay, thank you, Judge.
And then I don't have a trial court certification.
Okay, I didn't know you wanted that ahead of time.
Yes. All right, and then for both parties, I'm reviewing the court admonishments. And the court admonishments and the judgment does not mirror the motion to revoke as far as the charge. So the charge in the judgment is assault, family choking, strangulation, second. The motion to revoke doesn't show that. The motion to revoke just lists this. If you're just reviewing it as a third degree, because there's no listing of it being assault, family choking, strangulation, second. So are there any motions?
Yes, Your Honor, can we step back for just 1 moment? Talk
Sure.
about Probation, thank you.
So
Yes, ma'am.
what's happening, and your attorney will need to make a decision on whether he wants to withdraw your pleas are true or not. The motion to revoke, it's listing this as a third degree felony just based upon the face. It's actually a second degree felony. So I'm assuming that they're going to ask to orally amend the motion to revoke, maybe not. Maybe they are just going to refile it, and your attorney can make whatever motions he wishes to make.
We can discuss.
All right. All right. If y'all want to step back and discuss that. And to Adriana? Oh, no problem. Oh, who's next? Okay.
Ban on not sure, I'm not sure that. You're not gonna think- Yeah, so did you get the proposal? As had been settings of forecast to on that. Yes. Basically, my lawyer and the self-defense and up on. And center site. Change the plea on. January 6th. Now I see it. Yeah, I am sorry.
Oh my God, gosh, I won't take that out of all, but I use it, so.
And December 2nd.
Thank you.
His fingers weak.
Sorry.
Yeah, it's weak. So I don't always catch those. Yeah. Staring, because like, you know, we're. So did it get out to the noise? I have it. Did you bring on Mr. Burgess, Jonathan Burgess? Morning. Seat 9, 4 down. Here's the motion. Somebody turned it off. I was like, I know there's a reason I'm not hearing. Yeah, I'm like, and everybody's whispering and mumbling. All right, on this one, are you able to pull the indictment? Okay, and I'll look on my end too. Oh. It popped up, yes.
She's here. Yes. In the back row. Turn on the left. We just walked in. Yes, he was in the back.
All right, counsel, on the indictment, she's the complainant.
I'm sorry.
On the indictment for this case, she's the complainant.
She's one of them, maybe, I think.
No, it says here that she's the complainant.
It's true, Your Honor. It was continuous as a charge. She's the complainant on 2 of them.
On two of us.
Yeah.
Yes.
And I didn't realize that when I,
That's
yeah.
fine.
So I
No,
didn't mean to
that's what-
misrepresent anything to the court, so.
Oh, no. I know you're a stand-up person. I appreciate that. But yeah, do you want me to print out the indictment for you?
Yes, please.
All right. Can you pass him the indictment that's being printed? Yes. Yes. Yeah.
Thanks.
Okay.
So that's what's going on. So if y'all want to have a hearing on that, I require that the complainant be present.
She's present.
Oh,
Yes, he had approached me earlier and I made him aware of this and I told him your procedure that if he wants to change the victim will be here, so
Okay.
he brought it here today.
all right. So I'll take that up. Just give me 2 minutes. Let me, it seems like Mr. Molina is ready on his case.
Sure, Judge.
And
Thank you.
we had already started the hearing on this.
Got it. Oh, thank you.
All right, we're back on the record in 2022 CR 0695. Can I see the State versus Dwayne Daniels? Could I have parties re-announce?
Want to get agenda for the state?
Ashley Jones for the state.
And someone know from Mr. Daniels?
All right, so everyone, we have a court reporter who is, should I say practicing? All right. So all of this whispering that y'all doing, you're discouraging her from continuing with this profession. So I need everybody to stop whispering. I need everybody to speak at the rate that I'm going because she's trying to build up her speed. What speed are you at now? So she's in the upper hundreds. And what speed do you need to be? 2.5. All right, so speak at the pace that I'm speaking at. So we're going to try this again. Court is calling 2022 CR 0695 State versus Dwayne Daniels. Could I have parties announced?
Monica Recheta for the state.
Ashley Jones for the state.
Tim Molina for Mr. Daniels.
And are you Mr. Daniels? All right. And just as a side note, if somebody says something and Cindy does this, which I appreciate, if they say something that you don't understand, it's best to ask them to repeat it, because otherwise, when you have to do a record, you're going to be trying to figure out what was said and it's too late. Okay? All right, so we're back on the record. Are there any motions?
Yes, Your Honor, the state would move to amend the motion to revoke probation to reflect the actual charge the defendant was placed on probation for, which is assault, family choking, strangulation, second degree.
Any objection?
No objection. That's the charge he's on probation for.
All right. And Mr. Daniels, your attorney has certain time to prepare for a hearing on this matter. Because the state is amending this today, that's not timely notice for your counsel. So counsel, do you still wish to proceed?
We do.
All right. And Mr. Daniels, do you still wish to proceed?
Yes, sir.
All right. Did you understand by pleading true to violations 34, 36, 37, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to 34, 36, and 37?
Yes, sir.
Court will find 34, 36, and 37 true. Is there a proposed agreement?
Your Honor, the state is recommending revocation. We can go open and punishment, but the state is recommending 4 years. This is the second MTR. Unfortunately, on the first MTR, the state had to waive new number one because we didn't have contact with the complainant. And then after the first MTR, new conditions were put in place, which were the parenting class, the MRT, and the accredited battery intervention and prevention program. The second MTR, there's also new number one in the same thing. Unfortunately, we cannot proceed on that one because we don't have contact with the complainant, but the defendant has shown that he cannot comply with the conditions. And for that reason, we're asking for 4 years.
All right. And defense?
4 years. I'm sorry. 4 years.
Your Honor, if we're proceeding even on the notion that there's waived number ones, then I would have to reset this for a contested hearing.
Well, what I can tell the defense, the court is not considering the new number one. The court is not considering the argument that he previously had a violation allegation of number one and the complainant did not show. Court is not considering any of that because the state did not proceed on that.
Okay.
So as far as making a determination of whether or not his probation should be revoked or not, the court is only proceeding on the evidence that's being presented to the court. And that is that this is his second violation. It's his second motion to revoke, and that he has pled true to 34, 36, and 37. So counsel, before you begin your argument, are you in agreement to revocation or no?
No, Your Honor.
All right, I'll hear your argument.
I was going to call Mr. Daniels to
All right,
testify.
can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Dwayne Everett Jr.
All right, you may proceed.
Mr. Daniels, I wanted to go over a few things over kind of the history of these programs that you've been ordered to do through the court. Initially, you were ordered to take the batterers intervention prevention program.
Yes, sir.
Okay, and I guess we'll start with that. How did that go initially?
All right, well, it's a 6-month program, roughly 6 months, 7 months. I was in the program for about 5 months, making payments. It's a $700 course, if I'm not mistaken. I was trying to keep paying the course. It's about $40 a week, roughly, and I couldn't afford to make a payment within with me doing this in 5 months. Almost done, and they cut me from the program.
And that issue brought you to court
Yes,
the first time.
yes.
And the court adjusted the programs to ways that they would be affordable? Or how did the program get adjusted?
They got adjusted. She asked me to take, Ms. Boyd told me to take another program that I completed successfully. Which I completed successfully. Yeah, that's what happened with the.
Okay.
Okay.
Okay, so here's the thing. You're mumbling.
I'm sorry.
The court reporters cannot hear. I can barely hear you.
Okay, I'll start over.
Yes, I know you have bass in your voice. Raise it so I can hear and so that everybody can hear.
Okay, with the BIP program, Ms. Boyd had, I had did another program in place of the BIP program, and I completed that one.
And that was the live domestic violence panel?
Yes, ma'am.
And that was completed?
Yes, ma'am.
Okay.
Okay. And then other courses, kind of what was your understanding of what you needed to do following that hearing?
I did understand I had a parenting class, and I also understood, well, that's what me and the probation officer was working on. The next program was the parenting class, and the bill was back reinformed again.
Okay, you mean the probation?
Yes.
Okay. Okay, and then somewhere in this mix, somehow your conditions were altered and amended and you were reordered into the BIT program that with the same financial obligation.
Yes, sir.
Okay, and I guess this parenting class.
Yes.
What happened on the second go around with we're actually talking today about the number 37. So what happened with the second round of BIT?
Same go around again, and I do know that probation is, you know, it is, it's a blessing, as you know. So I take care of my children and my home, and I'm having just difficulty paying the arrangement with the course of the classes. I have no problem taking the classes. I know it's a privilege. And I have no problem taking the class. It's just I'm having a hard time with paying the fees of the class.
Well, explain to the judge what you went through with your attempts to sign up and the payment for the class.
They wanted $50 down, and I told them I get paid every 2 weeks, and she aware me that she wouldn't be able to put me in the class until the payment was made. And when I attempted to make the payment, she awared me that it would be the 100, and I wasn't able to make the payment. She did not allow me to reassign in the course, and that's basically what happened with the bill.
Okay, and then the parenting class, what was was that a free class?
No, sir. The parenting class is a $500 course as well, and I'm just having a difficult time financially.
What do you do for a living?
I work for a turnaround company, turnaround pools, cleaning pool service. And I also work for a DBK lawn care service.
You have any children?
Yes, sir. I have 4 boys. I take care of the older 3. They live with me, take them to school. I pay for their clothes, etc. As a father should.
Okay. And one of your sons is actually out in the hall with a small child.
Yes, sir.
And then you have a sister that's local to Kiara Daniels.
Yes, sir.
Why bring children to court?
His sister wanted to come on his behalf, and it's her child, and so she just left him in the
Okay.
home. Right.
All right, so here's the thing. And I'm gonna get to the issue. All right, he was here last time. The court did alternate amend his conditions to include the live domestic violence panel. Does anyone have any proof that he did not complete that? Probation, did he complete the live domestic violence panel?
Yes, Your Honor.
All right, so, and the reason why the court ordered that from last time, my mind is a steel trap, is because he did 4 months of the BIP course, and then he was discharged from BIP for non-payment. And so everyone came up with the agreement that he would do the live domestic violence course because he couldn't afford BIP. And then with parenting classes, I don't understand the cost of that parenting class because there are online courses that are like $20, $25.
And Your Honor, we do have his probation officer, if the court would like some more context for that. But my understanding of the record was he did do the family violence live panel originally because he couldn't afford the BIP, but then he got the first NTR. And the first NTR, that's when all of these conditions were ordered. And then hasn't complied with those. So that's my understanding of the timeline.
My understanding of the timeline is he had a motion to revoke. There was a new number one, which I'm not considering that. And that was the only thing that was on the motion to revoke.
That is correct, Your Honor.
All right. And then at that point, there was an alternative one. The motion was withdrawn because y'all couldn't prove up the number one. And then I had previously ordered live domestic violence panel, which he completed. So is anyone here going to dispute that he can't afford the BIP course? I mean, because the only evidence I have is that he can't afford the BIP and that he can't afford parenting classes. If he can't afford the BIP course, which is what he's pled true to for failing to attend that, 34 is the parenting classes. He's saying it's how much? $500 when there should be one online that's for $20. And then the MRT, with the MRT, is there a fee associated with that?
Yes, sir.
And how much is the MRT? How much is the MRT?
Approximately 600.
Approximately
$600.
$600 for MRT, $500 for parenting classes. We're at $1,100, and then $50 a week for the BIP course. I don't know anybody who can afford that. I can't afford that.
Sure.
But I will tell you, I'm not considering it, but I do see the issue with these number ones. So what I can tell both parties, I will listen to the rest of the evidence, but it appears here what there needs to be is there needs to be a GPS, no contact with whatever address this complainant is at, and no contact with that complainant. That's what it appears needs to happen here. And he has already completed the live domestic violence course. He doesn't, are you losing here?
No.
It appears that he can't afford the BIPP course. So he can't afford it. Is there money for that he can get? Can he take that course and pay for it in installments? Does anybody know?
Your Honor, can we call his probation officer to the stand just to get a little bit more information?
Sure.
Mrs. Hendrick, the state call, Mrs. Hendrick.
Do you have any objection to going out of order with them calling the probation?
I don't.
I've already told people where I am. If somebody can't afford a program, I can't revoke them because they can't afford a program. Hi. Hi, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Drusilla Hickman.
All right. Is there any funding for people who can't afford the BIP course?
Not to my knowledge.
All right. Is there any parenting classes that cost less than $500 that are online? I've seen some for like $20, $30.
Yes, ma'am.
All right. Questions?
Thank you, Your Honor. Has the defendant ever expressed to you his inability to pay for these classes?
He's not expressed to me directly, no, ma'am.
And have you worked with the defendant to offer him referrals for better employment?
Yes, ma'am.
Can you talk to us about that, what you've done?
Yes, everything that we get through the reentry center as far as job fairs and stuff, we actually email those to the probation.
Right, so you provided him with better employment opportunities?
Yes, ma'am, and we have flyers as well on our doors and offices.
And can you talk to me about, have you spoken to the defendant about his non-completion of these programs?
Yes, I have.
And how did that conversation go?
My recollection is that he will get it. He has been offered resources, referrals. I've printed them out and have emailed him for those classes.
For the
parenting, the BIP,
okay,
and the MRT class.
Okay. What other efforts have you provided the defendant to help complete these classes?
Just have them look at there's, on the forms, there's online and in person. And I have stated also for the parenting, since it is the lesser of the classes, we're gonna start with that first.
And has he made any attempt to start with parenting class?
No, ma'am. I have documented that on October 17th, an office visit that the next week after he gets paid, he would sign up for the class. And he would send info regarding when he'd be enrolled in that class, as well as in December as well. I had printed out resources classes for him to take and nothing from there.
And how would you describe just generally how this probationer has been as your probationer?
I mean, he has showed up for every office visit. He's been negative on his drug test and he's been fine otherwise.
Except for the completion of these classes.
Correct.
And these classes, are they meant to help him with his thinking and his criminal behavior?
Yes, ma'am.
Okay. I'll pass the witness, Your Honor.
Any questions?
How long have you yourself supervised Mr. Daniels?
I have supervised Mr. Daniels since October 25.
I don't think I have any other questions. Thank you, Judge.
All right. Thank you so much. Thank you for coming down.
You're welcome. Thank you, Your Honor.
All right. So here's the thing. I don't understand. I know states you're asking for revocation. Legally, there's no way for me to revoke somebody because they can't afford to pay. He says he has 2 jobs. Nobody has given me anything to show that he's being dishonest when he says he has 2 jobs. And if, when you think about it, anybody, even on a prosecutor's salary, can people afford, over $1,500 for programs? Should he be taking these programs? Yes. Do I have concerns about the complainant for these new number 1 violations? Yes, I'm not taking that in consideration because the state hasn't presented me any evidence when I was a prosecutor and I thought somebody was in danger. I know the people over batterer's intervention and all these other people would get upset with me, but as a prosecutor, you know what I would do? I would file a subpoena and I would attach that person. Nobody's done that. All you have to do is attach the witness and have them come in. Because do I think he's probably a danger to this person? Yes, but I can't consider any of that because you all have waived and abandoned violation of condition number 1, and this is not the first time you've done it. All right, this is what the court is going to do. Court is finding violations of 34, 36, 37 true. The court is going to deny the motion, alternate mean conditions to include 180 days in the Bexar County Jail, and that's going to be served day for day. By that time, you can contact the complainant and tell them they have 180 days. There's going to be partial GPS for employment only. Waive GPS fees. And I'm pretty sure I already have a no contact with the complainant in place. So if you all have addresses, give those addresses to probation. He's not to be anywhere near there. And then if he violates the GPS, you can file a motion to revoke. You don't need the complainant. You just need somebody to come in from GPS to say he was in a location where he was not supposed to be.
Yeah.
Can I ask 2 questions?
Yes.
On GPS, once he is out of jail, would the court consider waiving the fees?
Yes, I'll do waive GPS fees.
And then also, Mr. Daniels has been in jail now for about 2 months. Would that credit apply to
No.
the 180-day sanction?
No. And he's going to be on GPS until further notice. All right, you can do that or you can do prison.
No, I'm saying I agree. That's fine with me now.
Oh, and let me just tell you what else should be fine with you. Stay away from the complainant.
Yes, ma'am.
Don't pick up the phone. Don't call. She doesn't want you anymore. I don't know what people don't understand. How old are you?
38 years old.
She doesn't want you,
Yes,
and
ma'am.
you're not a good for her. That's why you're here for the charge that you have. Be a man. Learn how to treat people with respect. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you.
Thank you, Judge.
And you said his sister's outside?
This is right here in the car.
All right, we're off the record. Where's the sister? right, here's what it is. Are y'all still proceeding on Jonathan Vargas?
Yes, Your Honor.
All right, if you'll come up. All right, who's here on Jesus Avina? Probation, this is an application. Court is calling 2025 CR 0000433 State versus Jesus Avina. Can I have the parties announced for the record?
Charles Blunt for the defendant.
And are you Mr. Avina?
Yes, Your Honor.
And I'm sorry, there are three cases. So the court is also calling 2025 CR 0000431 and 2025 CR 0000430. Right. Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Avina, in each cause number, did you review? Sorry, just one moment. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
And each cause number, did you review the true bill of indictments with your attorney? Did you understand it?
Yes, Your Honor.
State and cause number. And cause number ending in 30, are you proceeding on the indictment as presented?
No, Judge, and each cause we're proceeding on the lesser included offense of deadly conduct with a firearm.
No objections.
Mr. Avina, in each cause number, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of deadly conduct firearm. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
And each of the cause numbers, if the court were to grant your application for deferred adjudication, if your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Avina, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen by entering into this pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, all the cases will run concurrently with each other. There's a $2,000 fine. State is recommending deferred adjudication, and they're proceeding on the lesser included offense of deadly conduct. Did you understand that to be your plea?
Yes, Your Honor.
State and defense?
Yes.
It is, Your Honor.
And each of the cases, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand
Yes, Your Honor.
any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be 200 hours of community service restitution, the MRT, and there's to be no Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to each cause number, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your Honor, the state offer states one in attachments in each cause.
No objections.
All right, state, you may be excused. In each cause, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
All right, are you employed?
Yes, Your Honor.
What do you do?
Asphalt,
And how long have you done asphalt?
it's gonna go for a year and a half or
Do you have any children?
no, Your Honor. On one on the way up.
All right. And do you reside with your parents?
Where do you live with?
Yeah, well, thanks.
I'm sorry?
My parents.
All right, and cause number 4, and the cause number ending, I'm sorry, in 3-3. This is what the court will do. Court is going to sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors. The court is going to order partial GPS for employment only for 30 days. Since this happened around Fiesta, you will not be having Fiesta this year. Do you understand?
Yes, Your Honor.
You need to unfold your arms. So there's going to be partial GPS for employment only for 30 days. And GPS, when can you all put him on GPS? And I'm going to ask that the fees are waived.
Your Honor, generally, it's like within 30 days, but Your Honor wants it sooner.
Oh, no, he needs to be on GPS before this week expires. He's not going to participate in any of the Fiesta events. All right, there is going to be 200 hours of community service restitution. 100 hours will be deducted for completion of the parenting classes, which I'm ordering. The remaining 100 hours will be deducted for completion of MRT. There's going to be field visits one time per month for 6 months. This is to run concurrent with (2025) CR 00430 and 2025 CR 00431. There should be no contact with the complainants that have been previously mentioned on the record. And I'm sorry, instead of the MRT, I'm sorry, we're going to keep the MRT, but instead of 100 hours deducted, it's going to be 50 hours deducted. And then I'm also going to order anger management, and the remaining 50 hours will be deducted upon completion of anger management. Is there anything else that you need from the court to be successful?
No, Your Honor.
Probation, anything else?
No, Your Honor.
All right, next we're going to move on. Let's see. And I'm sorry, Counselor, that cause number, Mr. Avena, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And also in that cause number, there is to be no possession of firearms. Next, we're going to move on to cause number 2025 CR 000431. Odyssey. And that cause number, the court is sentencing you under the offense of deadly conduct of 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment in 45 days, no employment as a home healthcare provider with minors, partial GPS for employment only for 30 days, waive fees, 200 hours of community service restitution. Court is going to order parenting classes. 100 hours will be deducted upon completion of parenting classes. 50 hours will be deducted upon completion of the MRT, and the remaining 50 hours will be deducted upon completion of anger management. There's to be field visits one time per month for 6 months. This is where I'm concurrent with 2025 CR 000430 and 2025 CR 000 433. There's to be no contact with the previous complainants listed and no possession of any firearms. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Next, we're going to move on to cause number 2025 CR 00430. Court is sentencing you to under the lesser included offense of daily conduct to 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider with minors, partial GPS for employment only for 30 days, waive fees, 200 hours community service restitution. There's to be parenting classes. Upon completion, deduct 100 hours of the community service restitution. MRT, deduct 50 hours of community service restitution upon completion. Anger management, deduct 50 hours of community service restitution upon completion. Field visits 1 time per month for 6 months. This is to run concurrent with 2025 CR 00043. 1 and 2025 CR 0000433. There's to be no contact with the complainants previously mentioned, and there's to be no possession of firearms. All right, did you review, in that case number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, you're young. You better start making better choices. And from here on out, everything you do, you need to ask yourself, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes.
If you have any questions or any concerns about anything, let probation know about it. All right?
Yes.
Good luck to you.
Thank you, Judge.
Thank you.
Kendall Smith, 7-3 down.
Kendall Smith.
Judge,
Yes.
Kendall Smith, I've called his name. I have a number for him. I've dialed before. I stepped out to dial it. He didn't answer.
Right, we're gonna go on the record. Court is calling 2026 CR 00305 State versus Kendall Tashawn Smith. Can I have parties announced?
Megan Galloway for state.
Joseph States in defense.
All right, this hearing was scheduled at 9 a.m. It is now 11:14 a.m. The defendant has not answered docket. Deputy, did you make an announcement? And what were the results?
Nobody else.
All right, defense, any contact?
I have a valid number that I know is valid through pretrial. I stepped outside. I called the number. I don't have current contact, Your Honor. And prior to today, I have made efforts to contact them as well.
All right, state.
Requesting a bond for Your Honor.
All right, the court will issue a judge's warrant, remand your client without bond.
Understood.
All right, thank you. Who's next?
It is Mr. Brown, Marcus Brown. Oh, he's not, she's still doing it. I have a reset for Derek Friend, it's 10-4.
Derek Friend.
That's Robert Porter.
Friend. All right, Daniel Friend, are you in the box?
Yeah, but Mr. Porter.
Porter stepped out.
You can go to the next one, Jeffrey Davila, he's 7-5 down.
Jeffrey Davila. All right, where are we on discovery?
Judge, he's been indicted for his DWI case. There's 2 other cases that are felonies that are still in intake. I've reviewed the DWI case, but it would not be very practical until I can check into the Agasol. There seems to be a good defense to it. But I think with one more setting, I can.
All right, and the aggravated assault, is that family violence or?
No, it's some kind of road rage deal.
All right, Norma, I need a reset for discovery, 30 days.
That looks.
All right, come back on May 18th.
Thank you, Judge.
Thank you. Yes, I'm ready.
It is Edward Ripio, he's on page 6, 5 down. He's ready? Ready? You're finished.
Eckert Santa Cruz Trejo? Is that who it is?
Yes.
All right, counsel, I know you just been appointed.
Yes, and thank you for excusing my appearance. I didn't plan on appearing before you today.
Oh, no problem. Let's go on the record. Court is calling 2026 CR 0026118. Are you Edgar Santa Cruz Trejo? Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. There was another attorney who was previously appointed to represent you, and they were appointed by the system. Had you had any contact with Attorney Perez? All right. Do you have any objections to an attorney being reassigned? All right. So your attorney is going to be Attorney Chacon. Do you have any objections to her being appointed? All right, then she is appointed.
Thank you, Judge. And I did talk to him. We went over some of the evidence that was in the state's file, and I'm sure I'll get the e-discovery in the next week or so.
Okay. All right, Ms. Ferguson, if you recall this for discovery in 30 days. All right, thank you. Once you sign the reset form, you excuse.
I'll bring it to you.
Who's next?
Oh, I'm sorry, he's Brown.
Brown?
Aristide Brown.
Yes.
Mr. Brown, I've already showed these to the state. If you can look at these, I intend to have them back so there's no exhibit numbers. And I will have 2 witnesses in the gallery hall.
Okay.
The youth in each of the photos is the same youth. It's his 6-year-old son.
Okay. All right, so what I can tell you all, in the photos that he's shown me, the person who has the word blessed on their hat, I know them. And when I say I know them from the community. I haven't had dinner with them, lunch or anything of that nature. So is there going to be a problem with the court hearing this?
Yeah, Judge. No, from the state.
Oh, Your Honor.
All right, the court is calling 2025 CR 011031 and 2025 CR 012488 State versus Aristide Brown III. Can I have parties announced?
Lauren Espinoza for the state.
Joseph states in defense.
And are you Mr. Brown?
Yes, ma'am.
All right, in these cases, you entered a plea. All right, and according to your plea, the state is opposed to your applications. And the PSI, was the PSI waived?
No, we ordered a PSI and we have a.
All right. Any objections to the court reviewing the PSI or TAP evaluation?
No objection.
No objection. I did make the notation.
No, just, you can keep that. Probation, could I have a copy of the PSI and TAP evaluation, please? Ah, thank you.
Yes, thank you.
All right, any objections to the PSI or TAP evaluation, state or the defense?
None from the state.
Just a correction, page 1, number of dependents. Page 2, he only has 1 dependent, that's his 6-year-old son. On page 3, it says there's a impact statement prepared, but there is no statement. The state does not have contact with the complainant for that one. Yes.
Okay.
On page 5, current employer. And page 7, where it talks about the employment with the Bill Miller and the statement regarding the financial status is poor, relying on his father for assistance, depends on others, not regularly working. That is not accurate anymore. He applied and received a significantly better paying job. He's currently employed with Aisin, AISIN. It's with transmissions for Toyota. It's full-time, over 40 hours a week. Aside from those, there's no corrections
All right, any witnesses state?
No, Judge, just argument.
Defense, any witnesses?
Yes, Judge, I have two witnesses. Should I proceed?
Yes.
Harris Ty Brown Jr. Brown. Make sure you speak loudly.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up for everyone to hear. And if you could state your name for the record.
Eric Stott Brown Jr.
All right, you may proceed.
Mr. Brown, your relationship to Mr. Brown the third. Your relationship,
That's my son. I'm his father.
and he currently resides with you.
Yes, sir.
You're aware of the cases that were before this judge currently?
Yes, sir.
All right, and can you tell me about your son? He's regarding work, he's currently employed.
Yes, he's currently employed. So, yeah,
He goes to work, he shows up, that's what he's supposed to do,
he goes to work every day. He also attends church.
and he has a son.
Yes,
How old
he's 6 years old.
Right, and he loves his son.
Yes, he does.
I know that there's some prior cases he has, but you love your son very much.
I do.
And you're aware that he had prior cases, most appear to be dismissed, but he has had some running with the law before.
Yes.
What will be different this time, like where he won't get in trouble in the future? You'll be around to help him?
Yes, he's been going to counseling with his uncle.
Speak up a little bit, please. I'm so sorry.
I don't know, everybody's whispering.
He did have, he was hanging around some not so good people. I'm not gonna say that good people, but he just made some bad choices in the past, but he's not living that life no more. He's got a good job now. He's attending church, so.
And he graduated high school?
Graduated high school. He did attend college for maybe about a year. But he seems to be going on the positive side.
But regarding the bad influence to the other kids or young adults, was there some interaction with those individuals, the bad people who came to your residence and damaged property?
I'm not sure. I just know that that they showed up at my property and damaged a rental car.
You're able to, you know that there was only 2 people wearing ski masks?
Yes.
Is there anything you want to tell this judge about granting the application for probation or deferred adjudication?
Yes. Judge, he seems to be going in the right direction. I know that he had some prior run-ins. He just kind of made some bad choices, and he is aware of that. We've talked numerous of times, and he is a good kid, but he just made some bad choices. And you would grant him probation. I think, now he just started a pretty good job where he can he have a chance to make it a career. At your mercy if you maybe give him probation so he can kind of like get his life on track.
Thank you, sir. Pass the witness.
Hello, Mr. Brown. My name's Lauren Espinoza. I'm one of the prosecutors for the state. I just have a few questions for you. So you state that Mr. Brown lives with you, correct?
Yes.
Where did he live in 2023?
2023. He was with me.
So he lived with you in 2023 when he picked up his assault bodily injury case?
Yes.
And you're aware that he was on probation for that, correct?
Yes.
And you're also aware he picked up an MTR for that, correct?
Yes.
Do you know the alleged complainant, Juan Ariozola?
No.
So you don't know him, that's not to be, that you don't know him to be one of Mr. Brown's friends?
No,
Okay. And you're aware that he was continued on that probation, right?
yes,
And then that probation, right, the MTR was triggered because of a new offense, right?
yes.
Do you recall what offense that was?
I'm not sure. I just know that there were some individuals that showed up at my house with ski masks and it triggered him.
So that's why he picked up the evading arrest with the vehicle in July of 2025?
That I'm not sure.
Okay. And then, you know, he has the July 2025 evading, right?
Yes,
And in 2025, he lived with you?
yes,
And he still lives with you today?
that's correct.
So what is different between 2023 and today, other than him having a new job? So how can we know that you're, I guess, are you saying to the court you're gonna supervise him and help him?
I am.
So what steps are you going to take to do that?
So he's basically, he's being around me more and, I'm kind of like, you know, guiding him. And, he's kind of like, he's going through counseling. And he's no longer, separating me. He's kind of separated himself from kind of like the negative things that's been associated with his life. He seems to be on a positive path now. Goes to work, comes home. He doesn't, you know, go out at night. Basically just goes home, he just goes to work, come home, get a son on the weekend, and that's basically it.
But you can't say with 100% certainty that he's not gonna get any new offenses, right?
I do know that for 100%. He's a different person. He's definitely a different person.
Okay, I have no further questions, Judge.
No further questions. May I call my next witness?
Just one moment. All right, thank you. All right, so from reviewing the PSI report, it appears that his criminal history is misdemeanor assault.
Yes, Judge.
All right, and everything else was dismissed.
Correct, that other DWI he did not plea on is UAC.
All right, this is what the court is going to do. The court is going to grant the application. So in the cause number 2025 CR 012488, state any request for length of deferred.
We would ask for 8 years, Judge.
All right, the court is going to sentence you to 8 years deferred adjudication under that cause number. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. And I noted that in the PSI, you're still testing positive for marijuana. You are not, marijuana is illegal in Texas unless you have a prescription for it. Do you understand?
Yes, ma'am.
And Your Honor,
Yes.
and may I interrupt you?
Mhm.
With the second witness, I didn't get to put something on. I think that would help.
Mhm.
If I could proffer, he was, in the PSI reported that he was shot by a stepfather in 2022. Things, a bad time of his life happened after that. He started using marijuana. He is open to coping with anxiety through seeing a doctor, but
All right.
but he
So
understands he can't use marijuana.
you're not allowed to use that unless you have a prescription for it.
Okay.
I understand the issues, but you're not allowed to do that, okay?
Yes.
All right, there's to be a MIC evaluation out of custody. There is to be a TAP evaluation. Well, the TAP evaluation, let me see what it's recommending. All right, probation, before we follow through on the TAP evaluation, let's see if there's the mental health issue is what's causing this. So I'm going to hold the TAP recommendations in abeyance until we have the MIC evaluation. There's going to be field visits 1 time per month until further notice. This is run concurrent with 2025 CR 011-031. There's a $1,200 fine that will be probated. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. 50 hours will be deducted upon completion of parenting. And then the remaining 50 hours, I will deduct 1 hour for every sober support meeting that is completed. And probation, he needs some sort of trauma evaluation.
Judge, I don't know if the big evaluation will encompass that,
It usually doesn't.
doesn't?
Yeah, so if you could see about getting him some kind of trauma care, and you say he's under doctor's care now?
No, not current. Is that correct, Mr. Brown? Or are you currently seeing a doctor for any anxiety medications?
So I was seeing the counselor.
Are you currently seeing a counselor or doctor? All right, then there needs to be a referral for Center for Healthcare Services. Probation, is there anything else?
No.
State, is there anything else?
Judge, did you say no firearms or possession of ammunition?
No, I'll add that.
Thank you, Judge.
So there's to be no possession of firearms or ammunition. And are you living with your father?
Yes, ma'am.
All right, and he's to reside with his father, Mr. Brown. And I'm assuming that's Aristide Brown Senior?
Junior.
Junior?
It's spelled the same.
Oh, because he's the third, yeah. All right, and he's to reside with his father. And if something happens and you want to move from your father's location, you'll need to get permission from the court. And if there's some kind of issue or emergency that develops between you and your father, or maybe he's putting you out, then you will still need to speak with probation. Do you understand? You can't just leave and go live wherever you want to live. You understand?
Yes, yeah.
Judge, there was one other condition,
Yes.
field visits once a month.
I believe you said field visits.
Yeah, I said field visits once a month until further notice. Thank you.
Thank you.
And Your Honor.
All right, yes.
Ms. Brown, the child that you have currently resides with the mother, not in your residence.
No.
If he would have permission to travel to visit for his child if it's out of county.
If it's out of county, he'll need to ask permission from the court. And if he's doing well, there would be no reason for that to be denied.
Thank you, Judge.
Probation will probably grant it
Nothing
without
further.
even coming to the court.
Okay.
All right, and in that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it? And did you sign it? Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Next, we're proceeding in cause number 2025 CR 011-031. All right, in that cause number, the court is going to sentence you to 8 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider with minors, MIC evaluation, out of custody, TAP recommendations in advance until MIC evaluation is complete, field visits 1 time per month until further notice. This is to run concurrent with 2025 CR 012-488. Take in consideration 2025 CR 012-499. There's a $1,200 fine that will be probated, 100 hours of community service restitution, 50 hours will be deducted upon completion of parenting classes. The remaining 50 hours will be deducted upon completion of defensive driving, which I should have ordered under the other one, but I'll do it under this one.
You had said sober support for the other, so is it sober support and or defensive driving or?
No, that's why I'm putting defensive driving in here. And I'm doing that because in the other case, there was evading. Trauma evaluation, refer to Center for Healthcare Services. no possession of firearms or ammunition, and he's to reside with his father, Aristide Brown, Jr. All right, in that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You're gonna have to start making better decisions. I know there's some potential mental health issues maybe. But I'm giving you what you need to help you. And if you don't follow through, you're potentially looking at prison time. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Thank you, Judge. You're welcome. Thank you. Who's next?
Daniel Friend.
Okay.
Daniel Friend, and he can talk.
Friend, Robert Porter. All right, defense, you're asking for a reset?
I am, Judge. On this case, based on what the MTR said, I've reached out to a potential witness from the Lone Star Offender Treatment Program, and I have not heard back from that.
All right, so how much time are you requesting?
Hopefully she gives me a call back.
Norma, set this for contested and set it mid May. Is that good for you, Mr. Porter?
That's good.
All right, we'll do the 18th, and I'll put on here, we're setting it for contested, but I know that you're trying to get a witness.
Okay, thank you, Judge. And if I get a hold of him soon, I'll approach the court.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. Who is next?
Joseph Gonzalez, page 4, 5 down.
Joseph Gonzalez. Joseph Gonzalez. All right, why were you late for court?
I was trying to log into the parking.
All right, so here's the thing.
Yeah,
You know where
that's fine.
court is, you know there are issues with parking. You need to be on time next time, okay?
Yes, ma'am. Thanks.
All right. I know it takes a lot because of the parking situation, so I understand. Just make sure you're on time, okay?
Yes, ma'am.
All right. All right, counsel, where are we on discovery?
Judge, there's a critical witness statement that the state's still trying to locate to see whether they have it and or if it's recorded on video.
Yes, Judge, we did attempt to reach out to that person with this alleged video, left a voicemail. We have not received it yet. I have tendered an offer, but I still would like, I mean, under the law, I'm required to turn over that video if it exists.
All right, Norma, set this for the end of May for discovery,
Yes, ma'am. Okay.
May 28th.
That's fine, Judge.
All right.
Thank you.
All right, you're welcome. Once you sign the reset form, you're excused. Who's next?
The next one is, Texas Convolta, page 6, at the bottom.
Jesus Hinojosa. All right, where are we on discovery?
The only thing lacking, Your Honor, are the CPS records, which when we sent this again out, they told us that they got some kind of a backlog going and they should disclose them to us today, hopefully. So I can provide that to Mr. Martinez. Other than that, that's the only thing that we're missing. Everything else has been disclosed.
All right, Norma, we can put this on the same day. Norma, if you'll put this down for the 28th as well for discovery.
Yeah.
All right, just have a seat. Once you sign the reset form, you'll be excused. All right, who's next?
The next one is going to be, Everett Vara, page 4.
Good morning. Edward, good morning. Edward Vara. Vera, thank you. Court is calling 2025 CR 015370 State versus Edward Vera. Can I have parties announced?
Lauren Espinoza for the state.
Patrick Lawrence for the defense.
Probation, this is an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Vera, did you review the application for deferred adjudication with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictment as
No,
presented?
Your Honor, state moves to waive count 2 and proceed solely on count 1.
Any objection?
No objections, Your Honor.
Mr. Vera, did you review the court admonishments and defendant's waivers with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, Your Honor.
You're charged with assault of a peace officer or judge as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into this agreement, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Vera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 1, waiving count 2. They're asking that there be a $1,200 fine and the state is recommending deferred adjudication. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be 120 hours of community service restitution and the APSE course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 1, how do you plead?
I plead no contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 in all attachments.
No objections, Your Honor.
State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
This time, we hope you follow the agreement.
All right, so why were you doing this?
Why was it doing what?
This offense? Why didn't you just answer the officer's questions? Why, according to this, you hit them? Why were you doing that?
Honestly, Your Honor, they attacked me first. They hit me first, and I wasn't on my medicine at the time. So technically, I reacted when I should not have.
What medication are you saying that you're on?
I'm on Serpro.
All right, so nowhere in the police report does it say that they hit him first. It says that they wanted to detain him. That's what it says. They said they made a traffic stop on the vehicle. And according to what I'm reading, the traffic stop was legal. And they said he didn't have any identification on him.
They didn't ask for that, Your Honor.
They said that he didn't have any identification on him, no valid form of identification. And then they wanted to detain you for their safety. You were aggressive verbally. And then they said they attempted to place you in handcuffs, but they said the two officers were not strong enough to handcuff you. And you told them you knew your rights. They said they placed you against the vehicle, and I know they didn't place him against the vehicle gently.
I placed myself against the vehicle, Your Honor, to hold my hands like this so they won't have to get it. My hands not selling them.
Well, no, you're supposed to have your hands behind you because they're trying to handcuff you.
They were after my, yes, Your Honor.
Okay. So are you seeing a doctor?
At the moment, yes, Your Honor.
And what do you see the doctor for?
For my mental health.
Right, and what is your diagnosis?
My diagnosis is bipolar.
All right, are you employed?
No, ma'am, I get disability at the moment.
Okay, do you have any children?
No, ma'am, not at the moment.
What do you mean, not at the moment?
I don't have no children.
Okay, are there any on the way?
No, ma'am.
All right, do you live by yourself or with someone else?
I stay with my mom.
Okay. All right, this is what the court is going to do. There's a $1,200 fine that will be probated. Proof of employment or disability within 45 days. So you're either going to be employed or show disability. There's to be no employment with a home healthcare provider or as with minors. Regular reporting by Zoom or in person. Regular random UAs. There's to be no possession of firearms or ammunition. Field visits one time per month until further notice. 120 hours of community service restitution. I'm going to order anger management. Once anger management is completed, the community service hours shall be deemed satisfied. There's to be TAP evaluation and mental health evaluation out of custody. Follow recommendations. And there's to be a referral to Center for Healthcare Services. Probation, is there anything else?
No, you're right.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, so from here on out, everything that you do, you need to ask yourself two questions. Could this potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If it's maybe, don't do it. If there are any issues or questions, let probation know about it, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
Thank you. Who's next?
David Gonzalez,
David Gonzalez.
Tina and Truck.
David Gonzalez.
We're just gonna be aware of working with people.
Oh, okay.
So I'm counsel on his other two cases, which are gonna get dismissed on that, so.
Okay. All right, then you can be excused.
Thank you. And
Thank you.
I have one more. We can do mine real quick.
All right, who's next?
It would be James Sanchez.
And judge on that case,
Just 1 second. What page? Sanchez.
yes. Yeah.
Yes, where are we on records from out of state?
Those have just been received and have been disclosed to defense.
I just downloaded them this morning, so.
All right. Oh, Norma,
Yeah.
set this for a jury trial and a plea deadline date. And if we could do it sometime in June. Is June good for the state?
June should be fine, yes, Your Honor.
All right. And defense?
Yes, Your Honor.
All right, that's gonna be your jury trial date. So either you're gonna work something out or you're gonna be in trial. Do you understand? All right, and you need to make sure you're on time. All right, thank you. Once you sign the reset form, you are excused. Who's next?
It is Mark Benya.
What page?
He's on, I'm sorry.
People are calling out names and,
He's on page, 10, one down.
Art Pena. I'm sorry, Arno Pena.
Oh, they put Art.
That's okay.
Oh,
Oh, just have a second. We're waiting for Mr. Bont.
Gustavo Jimenez. Page one down.
Gustavo Jimenez. Hello,
Hi, Judge. Good morning. Good morning.
good morning. Hi. I remember you. Okay, let me see. This will pull up. Right, so where we are with the evaluation.
Judge, I was able to talk to the chiefs and management up top. There is funding that has been secured. We just need to make the arrangements with Dr. Scott to make the new insanity evaluation. So it's in the process.
Here's the thing, I understand it's in the process, but it's been in the process since February.
Your Honor, if I may, we
Yes.
did also just receive a new offer from the state.
Mhm.
I need to do my due diligence and do some computing of the time that he was at the Kerrville State Hospital to see about if he wants to pursue that avenue, Judge. We wanted to see if the court would entertain this case being recalled till tomorrow. I'm gonna be here for mental health court. And I think we'll have a better look at resolving this case and I'll be able to evaluate the counter with my client. That's okay with the court.
Sure. Norma, recall this for tomorrow.
Yeah, ma'am.
All right, thank you. We'll see you tomorrow. And then
Thank you, Your Honor.
we'll see, I guess, hold off on spending money yet. And the other thing.
Yes, Your Honor.
All right, thank
Thanks
you.
very much.
All right, who's next? Jeremy Bass.
Morning, Your Honor.
Morning.
Morning.
Good morning.
So this is a case, Your Honor,
Mhm.
where we've given the defendant time to come up with restitution.
Mhm.
He's been able to come up with 5,000 of the 8,000. He talked to him last night and he assured me that by the end of May, he should have the other 3,000, Your Honor.
All right, Ms. Ferguson, recall this for me. Yes. All right.
That's perfect. That's actually a Thursday too, so. That's
Okay.
good.
It's kind of perfect. Judge,
Oh, kind
I get out of school June 3rd. I'll be here June 3rd, happy.
All right, Norma, can you call it for the first Thursday in June?
Yes, ma'am. Thank you. Is that okay, Judge?
Yes, are you okay with the June 4th?
Fine. June 7th is my daughter's birthday, but the 4th is, that's perfect.
All right, so June 4th.
Thank you, Your Honor. All right, and we'll get paperwork.
Okay. Oh, come here. Okay, payment, who do I?
We'll talk to the state.
Oh,
All right, who's next?
Louis, where's Bob?
that's me as well.
All right. Luis Salinas.
Your Honor, he's in custody. I believe we have an agreement on that. I was just kind of jumping, seeing if I'm gonna be able to get this done by this morning.
All right, it's probably not gonna happen this morning. You can come back this afternoon.
I can't, so, what's,
Well, if you do the paperwork, you can be by Zoom. And I can do it for tomorrow.
yes, ma'am.
All right, Norma, recall this for tomorrow for disposition.
Yes, ma'am.
Thank you, Judge.
You're welcome.
Hold on.
All right, who's next?
Okay, Marcus, you know that, page 6 of the app?
One judge.
Good morning.
This is our very first sitting.
Okay, where are we on discovery?
We are looking into discovery. I gotta review all kinds of things, Judge. Plus the state needs the opportunity to try to talk to the complainant in the case.
All right, what date? 30 days?
30 days would be great, Your Honor. 60 is great.
Need a 30-day reset? 30-day reset for what date?
May 18th.
All right, we'll bring you back on May 18th. If your attorney wants you back sooner, we'll let you know.
Thank you very much.
All right, thank you.
Thank you, Judge. I'll be judging you.
All right, who's next?
Bill, he's on page 3 at the bottom of the plea, Judge.
Court is calling 2025 CR 015165 State versus Matthew Hill. Can I have parties announced?
Kevin Collins from defense, Your Honor.
And are you Mr. Hill?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hill, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Hill, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with theft of property, $2,500 to $30,000. As a state jail felony, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yeah.
I mean, yes, sorry.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes.
Mr. Hill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $1,000 fine, probated. State recommends deferred adjudication. There's to be restitution of $12,398.73 to Randolph Brooks, to North Park Lexus. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be 100 hours of community service restitution, felony theft course, and MRT. Did you understand those are recommendations from the court, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Judge, you have to say exhibit number one, including all attachments.
All right, did you review the waiver and stipulations with, any objections?
No.
Did you review the waiver and stipulations with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. When will you have this $12,000 paid off?
I can have it by this week.
All
I
right.
have it now and it's.
We have a judge. We just have to work it through probation. We have it ready.
All right, so what we're gonna do, Norma, recall this for the end of April, and you all need to have paid the amount?
Yeah, sure. We'd waive PSR judge, but we can,
Well, I mean, when is it going to be paid?
we got the check.
I mean, yeah, we have it. I mean, I can get it like tomorrow, for example.
All right, so then we'll recall it for the end of April, pay it, and then I'll sentence him. And you're waiving PSI, is that correct?
Correct.
All right, which date, Ms. Ferguson? All right, so we'll be back on April 30th.
Yes.
And counsel, you can appear in person or appear by Zoom.
Okay, appreciate it, Judge. I was just checking to
Thank
see
you.
if I'm around.
Don't
Yeah,
tell me you're gonna be out of the
no,
country.
I'm not. I'm gonna be here.
We're gonna be jealous.
No, Judge, I'll be here. Yes, thank you so much.
Thank you.
Appreciate it.
All right, once you sign the reset form, you are excused.
Thank you. Go ahead. Thanks.
All right, Charles Bunk,
Yes, Judge, I'm down here.
are you ready on the case involving Doug Campbell?
Yes, Judge.
All right, can I have the file on that? And what is his name?
Arnold Penny.
Can I see Arnold Pena, please? All right, court is calling 2025 CR 010725 State versus Arnold Pena. Can I have parties announced for the record for the
Madam President,
state?
state.
Charles Buck on behalf of Mr. Pena.
And are you Mr. Pena?
Yes, ma'am.
All right, in this case, defense attorney Charles Bunk was appointed to represent Mr. Pena. He was appointed after the plea was completed on January 6, 2026. And that was with attorney Doug Campbell. And defense counsel is asking that the plea be withdrawn. State, have you had a chance to review the defense counsel's motion?
We have judge and we are ready.
All right, and state, are you in agreement with the defense's motion or no?
We are not judge. We are opposed.
All right, defense, you may
Hey,
proceed.
Judge, just, and so the record's clear, his previous attorney filed, Mr. Douglas Campbell filed the motion to withdraw as counsel and the motion to withdraw his plea simultaneously. So the motion before the court includes both. So the court is aware, so I came on board, just so the record's clear, I came on board after the motion to withdraw the plea was already filed.
Yes.
Okay. So on behalf of my client, I'll call him as a witness for the purposes of this.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Arnold Pena.
All right, you may proceed.
Thank you, Judge. Mr. Pena, what, the things I spoke to the court about regarding when you and I met, was that factually correct?
Yes, ma'am.
And I did not represent you in any capacity up until the day that Mr. Campbell withdrew as your lawyer and filed the motion to withdraw the plea on your behalf. Is that correct?
Yes, sir.
Now, since then, you and I have had a chance to meet a couple of times and we've discussed the motion and we've looked at discovering some of those things as well. Is that correct?
Yes, sir.
Now, the motion that Mr. Campbell filed on your behalf one of the things it alleges is that, you had some questions or you lacked the understanding of the viability of a self-defense claim. Is that correct?
Yes.
So tell the court a little bit about, did you know that you could have possibly used self-defense?
Yeah.
But was it explained to you that you would have a trial? Was I the first person to explain to you, you would have a trial and that instruction would be given as to self-defense and what effect that could have on the jury trial?
And Judge, if I may, I'm gonna object. We're getting into things that are privileged by attorney-client privilege, and that has not been waived as of yet by the defendant.
You wanna, are you okay to waive that privilege you and I have and discuss what the discussions you and I've had regarding the self-defense issue? No, okay. Now, well, then you just tell the court on your behalf why you believe Mr. Campbell didn't inform you properly and what other things you think Mr. Campbell did that affected your inability to understand the plea you were entering into.
And Judge, I'm again gonna object. We're getting into things that are privileged by attorney-client privilege.
Mr. Campbell is no longer your attorney. Will you waive that privilege so you can answer those questions?
Yes.
All right. You
Go
may
ahead.
proceed.
At first,
Well, here's the thing. I want you to listen specifically to the question that Mr. Bonk is asking you. And that's the question that you need to answer. Do you understand?
Yes.
And what I can tell you, based upon this motion, there are potential allegations in it that relieves Mr. Campbell of his confidentiality with client. You understand? All right, so listen to the question that's being asked by Mr. Bonk. And the only thing the court is focused on at this point is the self-defense issue that is being raised or potentially raised by this attorney with the questions. Do you understand? All right, Mr. Bonk, you may ask your question.
Without talking about what you and I spoke about, did you and I discuss self-defense and how self-defense was applicable in cases like yours?
Yes.
Okay. Now, go backwards to the conversations you had with your prior attorney and tell the court what discussions, if any, you had about self-defense with Mr. Campbell and what your understandings were after those discussions.
We really didn't discuss much of the self-defense. The only thing that he brought up to my attention was if I signed on the 25 cap.
Okay, so here's the thing. You need to speak up because the court reporter can't hear, I can't hear.
I'm sorry. He didn't bring up much of the self-defense. When he talked about the 25 cap, yeah, told me if I sign on the 25 cap, when we go to the jury trial, they can't go above the 25 cap.
So in fact, in this case, you entered a plea, is that correct?
Yes. And
the 25 cap you're discussing, that was the deal that you and Mr. Campbell worked out with the state to avoid having to have a trial. Was that your understanding?
Yes.
So you understand that if the court today was to deny your motion to withdraw your plea, then the plea bargain that you entered into is what goes into effect today. Okay. Now, regarding self-defense, you said earlier a few minutes ago, you know what self-defense is from a layperson's position, correct?
Yes.
And I've asked you if you and I discussed it in a trial, on the strategy of a trial, without going into what we discussed. And did we discuss that?
Yeah.
And was that the same or different from the conversations you and Mr. Campbell had about your rights to raise self-defense if you had a trial, or what that would entail?
Completely different.
And tell us how so. Tell us regarding your conversation with Mr. Campbell, not your conversations with me.
Bare minimum, he didn't even bring up the self-defense. He really just avoided the situation pretty much.
Okay, some other things that are raised in this motion is that, specifically talks about the fact who the aggressor was, what your, you know, in your opinion, based on your having been there, what you thought was reasonable, who the aggressor was and those types of things. Did you and Mr. Campbell discuss all of that?
No.
Okay. Now, once again, without talking about what you and I talked about, did you and I have a chance to go through all the evidence?
Yes.
And videos and those types of things?
Yes.
And compare or contrast, or was that the same evidence that you saw with Mr. Campbell?
No.
Okay. Part of the motion also, you know, this basically says that you're claiming on your behalf that, and once again, I didn't file this, you're claiming, or Mr. Campbell on your behalf says, you know, there's different, you know, the self-defense allegation, potentially ineffective assistance of counsel. Do you know what that means?
No.
And okay, ineffective assistance of counsel is when you're telling the judge, you know, that your lawyer didn't do the job he should have done, that type of thing. And the motion seems to indicate that that's something you're concerned about. What do you want the judge to know about that? Because I certainly wasn't part of any of that.
The fact that he wasn't really doing his part, I would call my wife to set up visits with him, and he wouldn't really set up any visits. We have talked about my discovery. He wouldn't really show much of my discovery. He had said that there was 3 videos, but he only ended up showing me 2. The fact that he has also said that there was 96 videos of the highway case. That I don't think that he really saw all 96 videos on my behalf.
Now, regarding the plea itself, do you remember the day you entered the plea?
Not exactly.
Okay. And from my reading the record, this honorable judge was not the individual, I don't think, that took your plea. Do you remember if it was this judge or if it was a different judge?
The one that signed on the plea, no.
Yeah, okay.
It wasn't the group.
It wasn't this judge, okay. Now, on that day, did Mr. Campbell go over the plea paperwork with you? The stuff that you signed and then the judge showed you at the time of the plea?
Yes.
Remember, typically the judge says, hey, is this your signature? And you say yes or no. And did you in fact sign the papers that you and Mr. Campbell went over?
Yes.
And did that judge ask you at that time whether or not you were entering this plea freely and voluntarily? And what was your answer to that? Yes, you were. So what has changed between that day and today to where you think, you know, the plea, you should be allowed to withdraw your plea?
The self-defense.
And specifically the self-defense. And that's, as I understand it, you're saying you didn't understand the manner which it could be used in your defense and the way a jury could get instructions during a trial and those types of things. Is that correct?
Yes.
Is there anything else you want the judge to know about your experiences with Mr. Campbell? Because I don't know anything about it, that you think she should know before she makes this decision?
No. Okay.
Okay. Now, the state, I think, is going to try to play some jail phone calls where at some point you talked to some family members and said, hey, you might try to use self-defense. You remember that?
I would have to hear it.
Okay, but does that sound like something you may have said?
Maybe.
Okay. And once again, that goes back to that you knew that self-defense was a real thing. You just didn't know legally how it could be applied to your case. Is that correct?
Yes.
Okay. So when you spoke to your family members on the phone, you weren't making any legal decisions or you were just saying, hey, I think that maybe this, in your opinion, based on the facts, that might be something that would be beneficial to you at some point.
Yes.
Is that correct? Okay. Then Judge, that's all I have at this point.
All right. Any questions?
Yes, Judge, a few. So, Mr. Pena, how many times did you meet with Mr. Campbell while you were client?
Less than a handful of times.
Okay. If you had to put a number to it.
I would say like 3.
3 times?
4 times.
Okay. 3 or 4?
I would say 3.
Around there. Okay. Let me ask you, Mr. Campbell, what is your understanding of self-defense?
I mean, Mr. Pena.
I'm sorry, Mr. Benny, yeah. What is your understanding of self-defense?
If someone's the aggressor, I could defend myself at any cost.
Okay, so basically, if someone's like, let's say I'm coming at you with a knife, or I got a gun and I'm pointing it at you, you're allowed to defend yourself, right?
Yes.
Okay. How long were you in jail?
About to hit my 9 months.
Okay. Were you in the main jail or the annex?
Main jail.
Okay. What floor is the law library on?
I would say,
Let me ask, did you ever go to the law library?
they don't let us go to the library.
They don't let y'all go. Are you aware that that's a violation of a couple of laws by the Berry County Sheriff's Office? So you sure you're not allowed to go to the law library?
I've never been to it.
Okay. But you have, from what you were saying, it sounds like you have a common idea of like what self-defense is.
Yeah.
Okay. Would it surprise you if that's pretty much, besides a few nuances, that's pretty on point with what the penal code says in Texas Penal Code 9.01? Okay, so you do have an understanding of self-defense. Okay. And when you were talking to Mr. Campbell, I believe you just specified that he glossed over self-defense, kind of avoid the situation.
Yes.
Did not talk about it entirely.
Yes.
So he didn't speak to you about self-defense at all.
Not really.
Okay. Mr. Pena. So we're on the record. You've been sworn to tell the truth here. So I'm gonna ask you again. You did not ever speak to Mr. Campbell about self-defense before January 6th, 2026.
They came up one time, that's about it.
So now it did come up. Okay. I'll pass witness judgment. Wait, hold on. Judge, I would ask that you take judicial notice of the court's file.
Any objection?
No.
And what specifically are you asking me to take notice of?
The court admonishment and defender's waiver and affidavit admonishments.
All right, so the court will take judicial notice of that.
Okay.
And the court has the plea paperwork.
Okay.
All right.
And I'm gonna ask. Well, I believe it's a 601.
Okay.
Okay. Judge, I'm showing to the defendant for the record what's been labeled as state exhibit number 1. Mr. Pena, can you tell me what this is?
I just thought it was- I feel,
Okay, I'm sorry, you need to speak up.
my case.
Yeah. Is this a copy of the paperwork that you signed when you took the plea?
Yeah.
Okay. Let's look on the page that is defendant's waivers and affidavit admonishments. Now, on the next page, there's a signature there. Can you tell me who signed that?
Me.
Okay. And that's saying that I've had my constitutional and legal rights explained to me by my attorney, and I have decided to waive my constitutional right to trial by jury and enter this plea before a judge. Did you agree to that? I have not been threatened, coerced, or placed in fear by any person to induce me to enter my plea. You agree to that? I understand the court's admonishments and as contained in this waiver. You agree to that? I am satisfied with the advice and representation of my attorney in this case. You signed for that, you agree to that, right? What's the date on the signature?
The 5th, January 5th.
January, looks like a 6. January 6th, is that about right? Okay.
Highlight that, the highlight. You highlighted all that. The original's not highlighted.
The real is not highlighted, no.
All right, any other questions?
Judge, I'd like to play 2 jail calls that are contained in state exhibit number 2, unless there is any objection by defense.
Yes, I object.
Okay. Judge,
Well,
he can refresh his memory with the jail call, so before, it's not being offered before the court, but if he's gonna say that he doesn't remember what he said on the jail call, it can be played for him.
All right, so what is, ask him the question, then see if he remembers. If he doesn't, then he can hear the jail call.
Okay. Mr. Pena, do you remember making a jail call on October 14th, 2025?
I make a lot of phone calls.
Okay, so you did make phone calls that day.
I make a lot of phone calls.
Okay. Do you remember talking to someone about self-defense that day?
I don't recall.
Okay. What about on December 12th, or I'm sorry, December 2nd, 2025? You remember making the jail call that day?
Like I said, I make a lot of phone calls.
Okay. You don't remember talking to anyone about self-defense that day?
No, I have to remember, I have to remember, read, at least listen to the phone call.
Okay. So if you listen to these, they would refresh your memory?
Yes, sir.
Okay.
All right, so but before we do that, is anyone planning on calling Attorney Doug Campbell?
We plan to call him for our case, Judge.
Are you planning on calling me?
In my case, no.
Yes. All right, so because Mr. Campbell is here,
I'm gonna go out of order. I don't mind.
yes, let's go out of order because the court is going to be taking a recess at 12:30.
Of course, Judge.
All right. So defense, you have no objection to going out of order?
No, not at all, Judge.
All right, state, who are you calling?
Judge, we'll call Mr. Campbell.
All right, Mr. Campbell. Hi. All right, can you raise your right hand? You're an officer of the court, but I'll swear you in. Do you solemnly swear or affirm that you will give true testimony?
I do.
All right, you can lower your hand, state your name for the record.
Doug Campbell.
State.
Mr. Campbell, how long have you been a licensed attorney in the state of Texas?
Right at 25 years.
Right around how many clients do you think you've represented in your time?
Over.
Okay. Do you have any kind of like board specializations or certifications, training, CLEs that you've gone to or conducted?
I've been to many CLEs.
All right, let's go.
Of the plea or at some of these meetings prior to that, to the day of the plea?
We discussed self-defense a couple of different times, but very specifically the day of the plea bargain.
Okay. And so not only did you discuss it, you also had another individual who's also a lawyer here in Texas and well-established. He came and discussed with Mr. Pena while Mr. Pena was like in the box, for lack of a better word, what self-defense would entail.
Yes.
Okay. And then briefly, you heard the discussion. Does the 3 or 4 meetings prior to that day sound approximately correct to you?
In addition to every single time we were in court, yes.
And you have any idea how many times you were in court? Was it a few or many?
Depends on how you define a few or many, but it was at least 6.
Okay. And at those meetings outside of the courtroom, did you have an opportunity to discuss, to review evidence with him?
Yes.
And do you have any recollection yourself of the discussions about 96 videos and those types of things and whether or not you had viewed those?
Not a specific number, but I have viewed all those videos. I also played for Mr. Pena a couple of the videos that were from the complaining witness's camera while he was in the box to show him what was going to be introduced.
Okay, but so that was the day of the plea. Had he seen those videos prior to the day of the plea as well, or was that the first time he had seen them?
That's the first time he had seen them.
That's all I have, Judge.
One quick question, Judge. Mr. Campbell, did you listen to the jail calls in state exam number 2?
Yes.
And was there a male voice on the lines?
Yes.
For both jail calls?
Yes.
Who was that male voice?
Arnold Pena.
And you recognize that from your representation with him?
Yes.
Okay, so the male voice on these 2 jail calls is Arnold Pena.
Yes.
We'll pass the witness, Judge.
All right, any objections to the court asking a couple of
No,
questions?
of course.
All right. Mr. Campbell, I just have a few questions. So with regards to any raising of any self-defense issues, you discussed that with Mr. Pena?
Yes.
And I believe I heard testimony that you also discussed it with the partner in the your law firm, Carl Alexander?
And with Mr. Pena, yes.
Yes. And to your knowledge, how long has Mr. Carl Alexander been practicing?
Over 20 years, I believe.
All right. And his 20 years of practice, is that primarily criminal law?
Yes.
All right. And did you have ample opportunity to discuss any self-defense issues or any other issues with your client?
I believe I did.
And did Mr. Alexander with you have ample opportunity to discuss any defense issues with Mr. Pena?
Yes.
And if you were going to proceed to jury trial in Mr. Pena's case, if he wanted to proceed with a jury trial, were you going to be the only attorney who was trying that, or was your law partner going to also try it with you?
Carl was going to sit with me.
Okay. And did you ever try to dissuade Mr. Pena from going to a jury trial?
Judge, it's Mr. Pena's decision. If he wanted to go to jury trial, I certainly would have been ready for it.
All right. Thank you. Any other questions?
The discussions that you and Carl had regarding self-defense on the day of the plea, was that the first time you had these in-depth discussions about self-defense with the defendant, or did you have discussions with him to that level prior to that day, if you remember?
We had had discussions about self-defense on them almost every single time we met. And I think Carl went a step further than I did, but there were also more specific questions that Mr. Pena had that day.
So even on the day of the trial, he still had questions about self-defense that he felt like needed answering to him?
Yes.
Okay, that's all I have, Judge.
All right, thank you. Any other witnesses?
Judge, we have one more witness unless defense
No,
wants to stipulate.
No, any other witness with regards to what the court has heard? Are you calling Mr. Alexander or anyone else?
No, Judge.
All right, do you have any other witnesses?
No.
All right, so defense, are you still asking that the plea be withdrawn?
Yes.
All right, and is there any stipulations to the state's DVD? State's exhibit number 2?
Stipulation?
Yeah, are you stipulating to it or are you objecting?
I'm
to it?
objecting to it.
All right, do you have a witness to?
Yes, Judge. The state will call Miss Sylvia Castillo.
All right. Sylvia Castillo,
Maybe excuse.
may he be excused? Yes.
I'm going to say
yes.
Yes. All right, for everyone else, we're taking a break after this. We're going on recess. Yes, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name.
Sylvia Castillo
All right, you may proceed.
Thank you. Ms. Castillo, how are you currently employed?
with IC Solutions.
Okay, and what are your duties with IC Solutions?
Director of Client Services and Custodian of Records for ICE.
Okay, and that would be custodian of records. Would that be custodian of jail calls, communications, but the inmates make?
Yes,
Okay, so let me ask you. Have you listened to the calls that remain on state examiner two?
yes,
To your knowledge, are they records that are kept in the course of a regular conducted business activity?
yes,
Okay, are they made at or near the time that they're created by someone with knowledge?
yes,
Is it within the duties of IC Solutions to keep these records?
yes,
And is that a regular course of activity for IC Solutions?
yes.
Judge, state would ask that state examiner number two be admitted to evidence pending objection.
Any objection? All right, state's exhibit number 2 is admitted without objection.
Thank you, Judge. Permission to publish?
Yes. Well, let me ask you this, State, are you planning on publishing that and then asking Mr. Pena questions about it?
Yes, Judge.
Okay, all right, you may publish.
And can she be, I mean,
Yeah.
I have no questions of this one.
All right, may the witness be excused?
Yes, Judge.
All right, thank you so much for coming down.
You're very welcome.
Thank you.
Actually, Sylvia, I'm so sorry. Can I ask a few more questions?
Sure.
Okay. Ms. Castillo, the two calls that you had, if I may see that?
Yes,
Yeah. Did you create this document?
printed it from our system.
Okay, so there are two calls that were made here. What were the dates of these calls?
12/2/2025 and 10/14/2025.
Now, both of these calls would have been made before the date of January 6th, 2025?
Or the date.
Yeah, okay, they were both,
After there, December 2025.
I'm sorry, January 6th, 2026. So these calls were made prior to that date?
Yes.
Okay, thank you.
Thank you.
My apologies, Judge.
No problem. All right, she excused?
She is excused by the.
All right, thank you.
Purpose of the record, I'll be playing the first call dated October 14th, 2025, starting at 6:09. When I got indicted, when I called you about making indicted. I got the court date, I'm gonna put origin submitted like there's an act court on Friday. I think I was like a Monday or Tuesday, yeah, I came over and visited me on the video. And if I go with how court did don't say you were talking to me about the court. Because as of right now, they're just going to leave something else. Then I go. Judge, I'll be playing the second call. That is dated December 2nd, 2025.
Then you, right, there's been before, there's nothing new to be. No, you got. You might.
No, baby, don't worry about it, my love. I mean, so if anything, like this, my lawyer was telling me that he's got 96 videos that he's got to watch. And he's so far, he's seen 6. So hopefully by now, he's already seen all of them. And he can come up with something, you know what I mean? And what I told him was,
Wait, so then, what was he gonna tell
Well, I'm seeking self-defense. So if everything worked out the way I said, like, I only saw one story, and it hasn't changed. And it's gonna match up to what happened. Other other than that, his story changed like twice. You know what I mean? He's gone from, oh, I was reporting a self-defense, I was recording a road rage, to, oh, I was in the road rage. So these stories are not matching up. And if everything works out, like I said, I mean, like I told I asked my lawyers, was if they haven't given me an offer, is that good? It's like, actually, it's okay. I can't say it's good, and I can't say it's bad, because some people will give them an offer, to like, hey, well, you are still, you did the crime, you gotta do the time, and I say, yeah, but I did self-defense, you know, I was protecting myself, because I know if everything, the way you told me your story, and it matched.
Judge, may I ask a few more questions of Mr. Pena?
Sure.
Mr. Pena, for a third time now, after hearing those jail calls, do you still continue to believe and state that you did not have any meetings with Mr. Campbell about self-defense, nor any awareness of self-defense?
That's not really what I said on the video, on the recording.
Clarify for me then. What did you say?
That I'm keen self-defense. Not that he talked about it.
So you're saying you're going to plead to something that you weren't aware of?
I have some idea of what self-defense is. That's why I kept saying that I wanted to plead. And even since I talked to Mr. Campbell the first time we talked, I was appealing self-defense.
The first time you testified that you never spoke with Mr. Campbell about self-defense, right?
Yeah.
And here you are not once but twice talking about after a lawyer's visit, you're going to plead self-defense.
Yeah.
Yeah. That's the witness, Judge.
Nonetheless, what you said earlier and what Mr. Campbell seemed to agree with, the first lengthy discussion you had about self-defense and what it was the day of the plea. And also, am I to understand that you had never, allegedly, as I understand it, there's a video of this crime occurring, is that correct? Or what they're saying, what the state says is the crime, it's the guy recorded it on his cell phone.
Yeah.
And you had never seen that at all until the day of you were in the courtroom you pled? That's the first time you ever saw the videos?
Yes.
Any other question? All right, thank you. All right, I will give you all my opinion at the end of April. I need to listen to the DVD because I didn't hear it very well. All right, thank you.